So we could get started. I'm going to reward those of you who are already here and seated. You get to vote. So I need a quick, you have to be decisive. I know this is the last hour of the day you want to be decisive, but you have to be decisive. So here's the quick voting question. Should I launch into the digital world, which could take up pretty much the remaining time, or should I first launch into a quick 30-minute overview of recent developments in disability law touching on all areas of law? So everybody who wants the quick overview, raise your hand. Oh, okay, all right. That takes care of that. So you will get a short presentation on this, but that's okay. If somebody wants to remember slide 101 for me, that would be helpful because that's what we'll come back to. Thank you. And I'm not going to mention this again. I'll just say if you were to purchase this, you would understand everything I'm talking about today. So, in case you have to run. And some of you may have to run. So, all right. So we're going to talk a little bit about everything for the next half hour or so. So the first thing I want to tell you is that the AHEAD appears to be working. What I mean by that is I'm reading more and more cases in which courts are reaching the merits in post-secondary cases. And from a civil rights perspective, I think that's a very good thing. Your House counsel might feel otherwise, but it means that we're getting to issues that we really want the courts to flesh out, such as qualification, or when academic deference is appropriate and when not. And we'll talk about what I mean by academic deference. Direct threat cases are coming up and being decided. Cases on when an accommodation is necessary are being decided. So remember that a reasonable accommodation doesn't have to be given to somebody unless it's necessary, but the question is, well, what the heck does necessary mean? What is included within the duty to accommodate versus what is a fundamental alteration or an undue burden, because those are limits on the duty to accommodate. So all of these kinds of issues are coming up. And there is more to come on the definition of disability. And I had a conversation in the washroom 2 minutes ago about this Rodden case, so I want to talk about this issue for a couple of minutes. First of all, the Justice Department issued what's called a Notice of Proposed Rulemaking, an NPRM. So Notice of Proposed Rulemaking means, hey, American public, we want to issue some new regulations. And we think that the way we're now setting out these regulations is what they should say, but we're going to give you a chance to comment on them. And the topic of the regulation, which is what I want you to know, is how you decide if someone does or does not have a disability when the alleged disability is a learning disability or ADHD. So remember, I told you certain disabilities are now virtually per se disabilities. Not in that list of per se disabilities is dyslexia, dyscalculia, dysgraphia, or ADHD. Those are all what they call spectrum disorders. And that means they can be severe, they can be mild. Most allergies are spectrum disorders. They can be severe, they can be mild. So they said in the higher ed context, this is a particularly important question. So couldn't be more on point to what is within your job purview. So I helped write the AHEAD comments in the NPRM and the CHAD comments on the NPRM. I'm very much looking forward to Justice issuing the final regulation. And I don't have a date for that, but I'm going to assume it's not going to be too long from now because it's not the most controversial regs Justice could issue. I'll be very interested to see what happens to the Justice guidance on threat to self, for example. So keep your eye open for this. But then I want to talk to you about the Rodden case, which somebody was nice enough to raise with me just a minute ago. So Rodden versus the American Board of Pediatrics. I have 40 slides in this, and I'm going to try to do it from memory. So Mr. Dr. Rodden is an exceptionally skillful doctor, and he works at CHOP, Children's Hospital of Philadelphia. And he has been noted for his skillful professional conduct. No one's ever complained about him. He's become a mentor. He's become a teacher. But as is true at 80% of children's hospitals, you have to be certified by the Pediatrics Board within a 5-year period of your starting your residency at the hospital. And Dr. Rodden, to save his soul, he cannot pass the ABP exam. And CHOP liked him so much that they actually gave him 2 extra chances to pass the exam. And he did get, I think, time and a half on some of the later times he took the exam. So question number 1 was Dr. Rodden an individual with a disability? And this was the first appellate brief that I got to work on after I retired, joining AHEAD and the Bazelon Institute in this matter. So the reason Dr. Rodden had challenges, for want of a better word, is twice during his medical school education, he had brain cancer. And in the course of his brain cancer, he had part of his brain surgically removed. He had radiation. He had chemotherapy. So from my perspective, cancer being a per se disability, I said to the Justice Department, let's just say his disability is cancer. And they said no. And my colleagues at AHEAD said no. And the reason that they said no, even though you can tell I don't agree with them, but the reason they said no is because his problem was what's called an acquired learning disability. That is, as a result of his cancer, he had acquired the characteristics of a severe case of dyslexia, let's say. So the ABP successfully argued in district court, even with the ADAAA, he's not an individual with a disability. Part of the way they argued it just completely ignored the ADAAA. And by the way, the court found for the ABP people, and I think the court ignored the ADAA as well. But in fairness to the court, this case raised a critical issue that has been gnawing at the bones of learning disability specialists forever. And that's this. To establish that an individual has, let's say, dyslexia, you take an IQ score, you take a performance score, and you look at the magnitude of the gap, right? But what if both scores are above that of the average person in the general population? You're supposed to be compared to the average person in the general population. And you might have a huge gap here, but what if your lowest score is still above that of the average person in the general population? Are you an individual with a disability under the ADAAA? And the district court said, heck no, for reasons that weren't very well articulated. But still, I get why this is an important issue, right? Why it's a very challenging issue. So the Justice Department, AHEAD, and the Bazelon Institute came in and said, wait a minute, under the ADAAA, it says that for spectrum disorder disabilities, that's a learning disability, for spectrum order disabilities, you're supposed to do a time, manner, and duration analysis. So a time, manner, and duration analysis is not, when you read, do you comprehend as well as the average person in the general population? That is a bottom line analysis, right? Or how good are your grades? Because lots of courts used to say, hey, if you got good enough grades to get into Harvard, you can't have a learning disability, right? It's a bottom line analysis. But we said, no, wait a minute, court. What you're supposed to be asking is, how hard is it for this person to read with the same comprehension as the average person in the general population? And if you use that measure, Dr. Rodden is a highly disabled individual because his fluency is much, much lower or slower than the average person in the general population, and he's trading fluency for comprehension. In other words, if you knock his fluency way, way down, his reading skills, his comprehension is sufficient. Now, Dr. Rodden, so let's take these two issues separately. Sorry, I'm doing 40 slides from memory. So the Justice Department, when it filed its brief, made that exact argument. And the appellate court said, we're going to assume that Dr. Rodden is an individual with a disability. Now, what that does is it undoes the damage of the district court, right? Because the district court's reasoning is no longer a precedent. But it doesn't set a new precedent, does it? Because it doesn't give its reasoning. We don't know why the court assumed. So if there's a silver lining, the silver lining is, if you want to argue, and at some of your schools, you know, you've got exceptionally bright students who also have learning disabilities. If you want to say to whoever's challenging you, well, that's the position of the United States, that's right. The brief of the United States said you do a time, manner, and duration analysis. So I ain't got a precedent. I got a brief filed by the United States, and the United States is who is supposed to be interpreting the final word on the ADAA. Okay. Now, second issue that comes up. So if we're going to assume that Dr. Rodden is an individual with a disability, what are the accommodations Dr. Rodden asked for? So he says, well, my real problem is word retrieval. That's what was damaged with the surgery and so on and so forth. I don't have the quick ability to recall terms. And the ABP is a 350-question, one-day, 6-hour multiple choice exam. And the ABP, according to Dr. Rodden, emphasizes short-term memory skills. So he says, well, at the least, you can allow me to bring in a word bank or a memory tool or an open book so that I can recall these terms. But what I'd really rather you did was you give me an essay exam, which doesn't emphasize short-term memory recall. And even better than that, if you really want to be a good guy, what you'll do is you'll have someone from the ABP follow me around for 2 weeks and see what a good doctor I am and waive the exam. So the ABP successfully argues, we're not going to do the portfolio, it's a fundamental alteration, because there's no consistency. You know, how would I say, well, this doctor compared to this doctor, this portfolio compared to this portfolio, and I ain't got $60,000 for each doctor who wants to do a portfolio because I'd have to assign somebody to follow them around for a couple weeks. Off the table. Essay exam, also off the table, and for much the same reason. It's like it's very hard, according to the ABP, to standardize essay exams. How could I construct an essay exam that would be the equivalent of what's covered in a 350-question multiple choice exam? 350 questions covers a heck of a lot of information. I can't, I could write a 2,000-page question, I suppose, right? But I can't really put together an essay exam that's going to be standardized. And by the way, every question costs us $3,500 to develop. So when you tell us, can this and develop this essay, you understand you're talking about thousands and thousands of dollars to develop this new exam. And so we can't do it. Open book recall list, they say BS. And here's why they say BS. They say this exam is not short questions out of context, pressing upon short-term memory skills, burdening short-term memory skills. Actually, this is the way the exam works. We give you a paragraph of symptoms, and then we ask you questions like, what's the lab test you should conduct? What's the most likely diagnosis? We consider this actually a very job-related, context-heavy, not short-term memory-heavy exam, and their expert witnesses were more persuasive than were Dr. Rodden's experts. And in fairness to the United States, AHEAD and NASPA Institute, Dr. Rodden's lawyer at the district court didn't have input from any of these organizations and didn't put on the evidence that would have been necessary. But in fairness to Dr. Rodden and his lawyer, I don't know if anybody could have convinced the court that these weren't fundamental alterations. So ultimately, it began as a case about who's an individual with a disability, but ended up in a case as what's a fundamental alteration in testing. Right? Okay. So we just saved 40 minutes. Okay. The digital world is front and center, and I think we're going to get into this in a little while, but I want you to know nothing is immune from scrutiny. Not websites, not online learning, not videos, not academic course management tools, not email systems, not kiosk systems. How many of you have like bank teller machines on your campus? How many of you dispense stadium tickets through kiosks? All there. And phone apps. Because I know a lot of people are moving to phone apps. I need you to know they need to be accessible to people with sensory impairments, people who are deaf and blind, hard of hearing, low vision. Okay. So I'll tell you, there's just one really interesting question on the horizon that I'm personally involved in, which probably impacts the more prestigious universities here, and in fact, some of them have been sued. I don't know if Harvard has been sued in this issue. I know MIT has. So the issue is this. When you post information on YouTube, for example, and no student is signing up for class, so this is not a MOOC where students sign up. This is not an online class where students sign up. But just to give away knowledge for free to the world, you put it up there on YouTube. Does that class have to be captioned? Does that class have to be accessible? Because the law is about customers, it's about program participants, it's about students, but this is about, for want of a better word, strangers, right? So the question is, when you put that kind of information up out to the universe, does that include the duty to caption? Does that include the duty to be accessible to people who are blind? And at this point, this is an unsettled question of law. If you were asking me about an online class, I'd say, caption it, no question, right? But you're in a relationship with those people, right? They're paying you tuition, or they're signing up, or they're getting grades, something. But here, we really are talking about people with whom you have no relationship. The other big issue which pertains to you all is, how many of you produce alternate media? Right. So the Publishers Guild is concerned about what Google is doing through the Hathi Trust. So I don't know how many of you know about the Hathi Trust, but the Hathi Trust is run by Google, and Google's goal is to scan every single book that are in post-secondary library systems. Every single PhD thesis that are in post-secondary library systems. And they're starting at the top. Obviously, they're for University of California, right? And they might get down to Harvard and University of Michigan in a while. Maybe Yale someday. So they're working their way down. So they have now scanned something like 2 million volumes. And the Authors Guild is going, excuse me, but we own, our members own copyrights to many of these books. And if somebody can just go online and get the book, why write? Right? So Google says, well, the courts say, there is a prima facie case of copyright infringement here. Prima facie means just first showing. Doesn't mean conclusive. So then they ask the question, do these materials qualify for the fair use exception? So you all are probably familiar with the fair use exception. You have professors that hand you a packet at the start of the semester like this, and it's like 3 paragraphs from this book and 2 paragraphs from this book. And they try to argue, well, if I'm only taking a little slice, I'm not violating copyright. But there's some professors that say a little slice is like 50 pages, and there's some professors that say a little slice is, just 3 paragraphs. And that's why you see in academic libraries on top of copying machines, be careful how much you copy because you may be violating copyright, right? So there is a fair use exception, and it allows you to take a little slice, not 50 pages, a little slice. And there's another fair use exemption, which is called the transformative use exception. So if you have a son, my son's age, he's 21, he understands the transformative use exception extremely well because this is the issue that all rappers face when they steal one another's music. How much do I have to remix it, change it, run it from backwards to forwards, turn it inside out, before it is so transformed that the copyright original artistic value is no longer there? Right? So the next test is impact on the marketplace. If Google scans all these books and then nobody can sell them anymore, that's a lot of impact on the marketplace, right? If it lowers the marketplace like 1%, maybe not such a big problem. So Google says, we clearly, I get the prima facie case, we clearly meet the fair use exemption. And most of the courts say so as well. And here's why. So what does Google do when it scans a book? Well, the first thing it does is it gives a copy back to the library, or it stores a copy for the library. So if there's a flood or an earthquake or whatever, you've got a copy of the book. So rare books, this could be useful. And besides which, rare books are so old, the copyright's probably expired anyway, so not a problem. Second thing is, now when you're doing research, particularly in literature, so let's say that you want to know every book that ever contains the following phrase, Romeo, Romeo, where art thou, O Romeo? You can go into the Google search, and it will list out the 25,000 books and the page number, and maybe even the paragraph number in which that phrase exists. But it won't give you the book. So the little slice, and also transformative use. Why? Because what you've created is a new research tool. You haven't handed the person the book, right? This isn't, and is it going to hurt the marketplace? No. In fact, now that you got out the 25,000 books, you may have to go purchase some of those 25,000 books. Okay, now what about producing alternate media for our students? Because here, do we produce the whole book? Yeah, we do. The court says this too is transformative use because these materials would not otherwise be accessible to individuals with disabilities. And because they would not otherwise be accessible to individuals with disabilities, there's no damage to the marketplace. Okay? Now, there's one important piece of advice I want to give you, though, in qualifying for this exception. Don't ever convert a book to alternate media that the student has not first purchased or rented. And I'm not even sure about rented. I am sure about purchased. And I know this from having talked to people who work for the guild, right? What they're concerned about is a student purchasing a book and putting it up on the internet. And you want to watch them come down and, fine thousands and thousands of dollars. They're going to be junkyard aggressive dogs about this issue. So I think you're perfectly safe doing the conversion, but I want you to be careful that you can document that the student either purchased the book or rented the book. Okay? And I'm more confident about purchase than rent, but I'm not going to guess because there's no precedent on that. Okay. Digital world. Academic deference. So one of the reasons why colleges and universities are frequently successful in court is because judges are not professors. So what do I mean by that? I mean, let's say you have a student who says, I was denied my PhD in biochemistry because I have dyslexia. How hard or easy would it be for a court to second guess a decision like that? They're not PhD biochemists, right? It's very, very hard to do. So where does it come up for us? Where it comes up for us is a school says this requested accommodation would be a fundamental alteration. So this is what came up at Boston University. Students wanted course substitutions, right, for foreign language requirements. And the school said, this is a fundamental alteration, we're not going to do it. And look at the jam that the court is in. Because if the court says, you're right, I'm not an academic, then are they enforcing the ADA? Are they guaranteeing the right to reasonable accommodation? No. On the other hand, if the court says, well, I can decide what is and what isn't fundamental without ever having any expertise in the field, that doesn't seem right either. So what courts do is they give deference by making you earn it. And the way you earn it, as they did in the Guckenberger case that I talked about this morning, is they make you form a committee. They make you ask what's the purpose of the academic requirement. They make you do, quote, a diligent, thorough, good faith search, all technical terms here, for alternatives that would not be a fundamental alteration. And remember that Boston University came back and said, now we're going to teach foreign languages in 3 different ways. Right? And the court was satisfied, okay, you did your diligent duty. What I want you to know, however, is courts are less willing to grant academic deference than they have been in the past. And it's going to be a less available tool. So one reason it's going to be a less available tool is schools used to get academic deference at what's called the summary judgment stage, which means that you file your paper, the student files his or her paper, and the court looking at the paper says, taking everything the parties say is true, there's no longer really a factual dispute here. On the material issues, there's no dispute, and I'm going to decide for the school. And the reason I'm going to decide for the school is all things being equal, the school is entitled to academic deference. Courts are now saying academic deference is inappropriate at the summary judgment stage, and I will only grant academic deference after a full hearing on the merits. And the reason for this is, why did Congress pass the ADAAA? So there would be a full hearing on the merits, right? That's what they wanted. They wanted the substantive issue of discrimination to be discussed. So courts are realizing if I grant deference too early in the case, I will prevent that from happening. And that's not what Congress told me to do. So I might grant academic deference, but only after I've heard the case on the merits. And here's what I really think is going on. Heaven forbid I should admit this. I think courts work backwards from the results they want. So if a court sees that a student's getting screwed they don't grant academic deference ever. And if a court thinks, I don't think the student has a real case, suddenly they're going to grant academic deference. And I know it's working backwards from result, and you shouldn't do it that way, but that's exactly what I think is going on. And the cases that I see this happening are some really interesting cases about people who are in the medical profession. So we have this individual by the name of Argenyi. Argenyi sued, Neil, help me here. Who did Argenyi sue? Creighton University. So Creighton University is a large Catholic university in Omaha, Nebraska. Very, very respected institution. They admitted Creighton, who is a deaf doctor, a deaf medical student. And Creighton wants in his classes and in his clinical assignments a real-time captionist. And by the way, he wears I want to say bilateral, thank you, got my fields mixed up, bilateral cochlear implants. Creighton asked for the real-time captionist, and, Argenyi asked for the real-time captionist, and Creighton says, most of the time, not all the time, most of the time, no. And Argenyi goes out and borrows $130,000 on top of his medical school tuition to pay for a real-time captionist. And finally, Creighton says, we don't care who pays for it, you can't have the real-time captionist. And then Argenyi, who's not flunking out, by the way, he's like a C student at this point, Argenyi sues. And the district court fines for Creighton. The first thing they say is, well, since Argenyi is not flunking out, this accommodation must not be necessary. Right? It's not necessary. And Creighton and his doctors go on the stand and they testify about how hard it is for Argenyi to hear what's said in the classroom or what the patients are saying in the clinical setting, and the estimate they give is he hears about 38% of all the information that's being put on. And Argenyi talks about how exhausting it is to go through medical school only hearing 38% of the information. And the district court says, these are self-serving statements and fines for Creighton. Argenyi appeals. And the conservative Eighth Circuit actually says the district court really got it wrong. The first thing it says is, necessary doesn't mean you'll drop dead if you don't get it. Necessary is a comparative term. Necessary to have an equal educational opportunity. And given that Argenyi and his doctors have testified he only hears 38% of the information, this can't be an equal educational opportunity, even if Argenyi isn't going to flunk out without this accommodation. And one piece of proof that Argenyi needs these real-time captionists is he spent $130,000 of his own money. Right? So the court says rather than being self-serving statements, actually he's the most reliable witness and source of information there is. Something you might tell the visiting math professor from Poland who doesn't want to take a student's word for the fact that they have, a need for time and a half on an exam. And then it goes to a jury trial. And in the jury trial, the jury says Creighton discriminated against Argenyi. He must be admitted for the rest of his medical school education, and he is to get real-time captioning or cued speech, which is another form of accommodation, for the rest of his medical school education. And for the rest of the education, Creighton has to pay for it. But since Creighton did not engage in deliberate indifference, remember those magical words from this morning? He's not entitled to the $130,000 he's already spent. Game's not over. Creighton's lawyers then call for a hearing on attorney's fees. They put in a demand for $500,000 in attorney's fees. And the court says, this isn't all that unreasonable. There are a few places where it's not justified, but as a whole, we're looking at something of this large magnitude. At which point, Creighton sits down with Argenius lawyers. Creighton's lawyers and Argenius lawyers meet. And after that, there's no more record because they had a confidential settlement. So I called Argenius' lawyer and said, did he get his $130,000? And she said, Paul, that's a confidential settlement, and I can't tell you. But I can tell you my client is very happy. So, the other interesting case about academic deference concerns a blind individual who wants to be a chiropractor. And if you only read one case this year, it's something versus, help me here, I'll get to this in a second. It's against the Palmer School of Chiropractic. There it is. If you only read one case this year, that's the case to read. And not only is it a beautiful piece of judicial literature, but it actually explains who's a qualified individual with a disability, what's an undue burden, what's a fundamental alteration, how each of these issues relate to one another. Is just beautifully, beautifully written. So here is an individual who's blind. He wants to be a chiropractor. He's doing very well in chiropractic school. And he's told by the dean, you know, next semester we're going to have to dismiss you. And he goes, why? He says, because next semester an essential requirement is learning to read x-rays. And you can't read x-rays. And this is, you know, part of the skill in the field of chiropractic. And I have to be honest with you and tell you, I was thinking to myself, game over. He wants a fundamental alteration. He wants to be excused from something that's really essential to what chiropractors do. And so here's the accommodation he asked for. Someone would stand next to him and read the x-ray to him, describe it. Right? Oh, there's a little light spot above a dark spot below and the school says, come on, this is a fundamental alteration, and he's not really reading the x-ray, right? And would you want your chiropractor to have somebody do this for you? So I'm going, game over. Court found for the plaintiff, found for the student. How in the hell can that be? So here's how in the hell it works. First of all, up until 2 years ago, Palmer did not require all students to have the ability to read x-rays. And Palmer is a chain, and in some of the chain locations, they still don't teach x-ray reading. And the reason is because the field of chiropractic is changing for an economic reason. It's much cheaper for a chiropractor to send their patients or clients to an x-ray place where they have the latest equipment and can afford all the insurance that it takes, do the x-ray, read the x-ray, and get on the phone and call back to the chiropractor and say, there's a bulging disc at C6. So it turns out this is not an essential requirement of the field. And given that Palmer itself recognizes this in 4 other locations, it's really not in a position to argue that it's essential. And nothing particularly unique, by the way, about licensing in, is this Iowa? I think this is Iowa, for this skill than any of these other places. So we're not into a state licensing requirement. So no academic deference. Palmer kept saying, don't we get to decide what skills our doctors should have? And in this case, the court said, well, we're not going to defer to you here. So I think we're seeing more and more of this, and it's going to expand our concept of who's qualified to be trained for what professions. Okay. Am I going FG right? Now I'm going back. Okay. We got that. Got to go back. Okay, you did that. You did that. Oh, I know. Yeah. Okay. So I'm going to go into this in some detail till you all leave. But I just want to point out for those of you who are leaving that the measures of equal opportunity in the digital world are adding new concepts that didn't exist in the brick and mortar world. But those concepts are now spreading from the digital world back to the brick and mortar world. So independence and self-sufficiency are really key measures in the digital world. In other words, it's not going to be, well, we'll have somebody read the screen to the student, right? That's not independent. It's not self-sufficient. The student has to be able to use the technology directly themselves. Well, what's happening then is this is now getting into, for example, emergency management cases, where the question is your system set up so that people with disabilities in an emergency can evacuate themselves or can safely get help? It's also coming up in voting cases, where a lot of times the voter registrar says, we'll have somebody sit down with you and mark your secret ballot for you, right? That's not acceptable. And the language for that is actually coming from these digital world cases. So we've done this, and we've done this. We did a whole long thing on threat to self, and as I tell people in my summary, it still hasn't been resolved. One cautionary note, for many years we have made distinctions between temporary and permanent disabilities. So people would call me on the phone and say, I have a kid who's in a cast, and he wants, as an accommodation, keys to all the elevators in the university. And I would say, oh, well, this is an easy one. He's not an individual with a disability. So whatever you want to do, do. Give him the key, don't give him the key, I don't care. But he's not an individual with a disability. And that's because the condition was going to last 6 months or less. Now the EOC under the ADAAA has made this a much, much fuzzier distinction. And so my advice to you now is, and I admit I'm simplifying here, is if somebody has a serious injury and it's going to last more than 3 months, accommodate them. So the key case was Summers versus Alterum Institute. Summers stepped off of a moving train, or started to move as he was stepping off, and he broke his hip in a very serious manner. And the employer said, oh, we don't need to accommodate you because you're only going to be in a cast for 6 months. And the EOC and ultimately the Justice Department and the court said, that's not the full analysis. If he is substantially impaired in a major life activity, and it's substantial, he could still be an individual with a disability, right? So my advice is, if somebody's going to be in a cast or injured for more than 3 months, you better treat them like an individual with a disability. Okay, so I'm going to take a swig of Coke, and we're going to go to slide 101, right? Does anybody have a burning desire to do service animals instead of the web world? Or is the web world cool? Web world is cool. Okay. It must be finally getting warm out, huh? Oh. Helpful, thank you. Okay. So this is from OCR's most recent letter of noncompliance to a university. It was at the University of Cincinnati, and it was about the virtual world. So I want to explain a practical thing to you. So here's where my insider's experience with OCR is really going to help you. Think of this hypothetical. You have a fiscal year, it's 12 months long. You're in the 11th month of the fiscal year, and you had a quota for compliance reviews. So compliance reviews are investigations that we initiate, not in response to a complaint. 90% of our work is in response to complaints, but 5% is compliance reviews. So I have a quota. I got to do 6 compliance reviews. I've done 4. I got to come up with 2 more compliance reviews in 1 month. And here's the thing. Compliance reviews are a pain in the ass because you got to get on a plane. You got to fly to the university. You got to interview people. You got to get a remedial agreement. The investigation, it takes a couple weeks to write up. I'm out of my budget for the fiscal year. What the hell am I going to do? So what the hell I'm going to do is I'm going to get on the internet, and I'm going to go to each of your websites, and I'm going to test it almost for no cost at all, almost instantaneously, for accessibility to individuals with disabilities. And if I got a problem, that same afternoon, I can get on the phone to your office and say, we found you in noncompliance, and we need to get a remedy. So God help you. Your face to the world better be accessible. So that first big, page that's full of untagged pictures and untagged PDFs and pull-down menus that blind people can't use, dump it. Get somebody in there who knows how to make for you an accessible web page. Make sure every picture is tagged. Don't use pull-down menus. And make sure that the information that the law requires you to tell people of is on that very first page. We're an equal employment, we're an equal opportunity employer, right? Make sure all that stuff is right there. Because if your first page is bad, we're going to dig, deeper and deeper and deeper. And we're going to find more and more non-compliance. So this was the summary in the very recent letter to the University of Cincinnati. And it says, entities subject to Title II are required to provide equally effective communication. So equally effective communication means the information that's communicated must be equally accessible and available to all your students, regardless of the medium chosen. So I don't care if you do it through online learning or you do it on a website or you do it through a phone app. Regardless of the medium chosen, you must provide equally effective communication. Communication by educational institutions includes the transfer of information and encompasses information conveyed through computer-related applications and online learning systems, which pretty much covers everything, doesn't it? With the one exception of maybe, as I said, what you put up on YouTube where you have, nobody register for your program. So we're going to go through this outline. I want to talk about new measures of equality. I want to talk about the legal authorities. We're going to talk about academic website access cases. And then if we have time, public accommodation website cases and a few other cases. So here is the new measures of equality, part of the title of this program. Independence of the user, and I'll tell you where all this came from in a second. Integration of the user. So how does integration come up? What this means is that the user gets to participate with all the other users. So if you have an online seminar, the individual with a disability gets to participate as fully in that online experience as does anyone else. Ease of use of the technology. So sometimes it's like, yeah, a blind person can get into this learning management system, but it's going to take them about 2 hours and 45 minutes to get to the first piece of information. That's not really equal ease of use. Timeliness of the delivery of information and the completeness of the information. So one of the reasons for this timeliness standard and the ease of the use standard is Some schools said, our website, we're not going to make it accessible, but we're going to set up an 800 number. And between 9 in the morning and 5 in the afternoon, a blind person can call this 800 number, and we'll register for them, or we'll read them what's on the slide, or we'll tell them how much tuition they owe us, or whatever. It's like, that is not equal ease of use or timeliness of delivery of information. If you can, be on the beach in the Bahamas, half naked, and enroll for classes, well, then a blind person has to be able to do that as well. So how is this achieved? So it's achieved by making the information available in formats that are compatible with common adaptive technology. JAWS and ZoomText are the #1, standards for accessible information. So if your website is not accessible through JAWS and ZoomText, you've got a problem. Another way of doing this, it's an additional responsibility, not a substitute responsibility, is making adaptive technology available around campus. So at a number of schools that I visit, if you go to the Learning Lab or the DSS office, JAWS and ZoomText is there, right? And students with disabilities can use it. If you go to the library, it's not there. If you go to the math lab, it's not there. If you go to the English lab, it's not there. That is a violation. Why? Because the people who are teaching the content are dispersed out at those labs, right? So you need to have your adaptive technology dispersed as well. It's also achieved by adopting access policies for your websites, for your online learning systems, and then training the people who are putting the content into those systems on what it means to be accessible. And I know that if I did not have at Hastings an individual who could sit next to me and show me how to do this stuff, I couldn't do it. So unless you're a teeny, teeny, tiny institution, you really need an EIT expert who can assist your faculty when they're putting this stuff together. Another way to achieve this goal that's becoming very, very important is to make accessibility a part of the acquisition process. So when you purchase a course management tool, you need to write right into the contract that a characteristic of the course management tool will be that it is accessible to individuals who use common adaptive technology. And don't let the salesman tell you, oh, we're 508 compliant. And chances are the salesman doesn't even know what the hell 508 compliant means. Make sure that if you take delivery of the product and it's not accessible, they, not you, are on the hook for making it accessible, because this can take a lot of time and cost a lot of money. And one thing I advise attorneys for colleges and universities, no ad hoc solutions, write-arounds, fixes after the fact. Get it right into the contract in the first place, unambiguously. This software will be accessible to individuals with visual and auditory impairments and will be usable with JAWS and ZoomText or whatever common adaptive tools you're going to use. Good prioritization. So you probably have, at least at your larger institutions, thousands and thousands of websites. You're going to have to figure out which websites am I going to make accessible first, right? So obviously, course registration, welcome to the university, how you get your grades, those things first, and then work backwards to some of your older materials. If you know that something's not accessible, then you need to plan for what will be our, temporary workaround. So I don't like 800 numbers as a long-term solution, but it might have to be a short-term solution. Let's at least make sure that the notice of the 800 number is easy to find. If I go to your website and you're counting on me using an 800 number, is it something I can get to with JAWS or ZoomText? Having somebody on your campus who's specifically responsible for this, and don't make it you, right? unless you have a degree in computer sciences, if they're making you do the human resources, the architectural access, and the digital information access, you should be making about $500,000 a year, right? Because these are all highly technical skills. What you do need to know is, hey, wait a minute, before we build that new building, we need an expert in who can tell us what's architecturally accessible. Hey, before we decide what academic software we're going to buy, we need someone who can tell us what software is accessible and what isn't. Now, I'm going to give you another piece of insider information. There's a place you can call, and most of the time you can get many of these questions, is this software accessible, answered for free. Okay, so it's the High Tech Training Center of the California Community College System, right? I'm sorry? Yes. The High Tech Training Center of the California Community College System. And if you promise not to mention my name, I will tell you who you want to talk to is Geyer, rhymes with fire, G-A-I-E-R, Dietrich, spelled diet rich. And if Geyer doesn't know the answer to the question, she can tell you who. And if you need somebody here in Massachusetts who can help you, Geyer might know who's good here for that purpose. Who is this about? This is about people with visual impairments, hearing impairments, and by the way, sometimes it's about people with manual impairments, right? Because there are people with disabilities who cannot mouse, but they can use a keyboard or they can use a mic. And it should be that you can navigate your screen with any one of those approaches. Who are you responsible to? So this is not just for your students. Applicants for admissions, prospective students, admittees who have not yet elected to attend, parents and guardians, guests and visitors, and even employees. What is covered? Damn near everything, and I think I've gone through this list already, but I just, I'll give you a chance to peruse it. I just want to add, because I don't think I emphasized it, your library is a really critical point in this system. Is your card catalog and research system accessible to individuals with sensory impairments? And for some reason, schools forget about the sites for filing complaints or getting services or going to the DSS office. So it's like, okay, I'm blind and I can't use this my OM Math Lab program. How do I find out who to complain to? Oh, that's a secret, right? It's not a secret to people who don't have the problem, right? They can see it right there in the nice picture on the website, but it is a secret to the people who have the disability. We've already done this. So I'm going to try not to bore you to death by reading to you all the regulations. But I just want to point out that this issue is covered by 504, so that covers you all. It's covered by Title II, so that covers those of you who are public. It's covered by Title III, which is those of you who are private institutions. And the standards that we talked about, they come from the Kindle letters, and I'll tell you about the Kindle letters in a second. If you have an information technology director at your school or a chief information officer, I urge that person to read the Kindle letter, and I also urge them to look at the Section 508 standards and the WIG-CAG Level 2 AA standards. And these are very technical. It's like I would be trying to tell you about architectural rules, right? I'm out of my league. But if they say to you, oh, there are no real standards yet published. We're still at sea about this. Not so. The Justice Department has used 508 and WCAG 2 Level 22A for a long time now in settlements. So we know what standards are out there at this time. And therefore, I'm going to skip, as I watch people fall asleep, I'm going to skip through this. So I want to tell you I think if I stop in 15 minutes and took questions, would people be happiest? So there's some vexatious thing that we're going to 4:30, right?
Well, we can go at 4:30.
What time?
I'll have them bring we have some little goodies for our reception, so
Okay.
I'll have them bring it in here.
Okay.
You can get up and come over here. Is everybody agreeable with it?
I just want to be helpful to you all, and I'm watching people nod off, and I'm not taking offense at it. I'm just going, if you have some vexatious question that your boss asked you to ask, I want to make sure that you get to ask it. So, so we'll go through this for another 10 minutes or so. So, the Kindle is produced by, help me out here, gang, Amazon. So Amazon wants to do to your student bookstore what iTunes did to the record store, right? They want your bookstore to be gone, and they want your students to buy every single book through Amazon. So they had this clever idea of how they were going to get their foot in the door, and that was they would get schools to agree to have Kindle-only sections of classes. These were mostly, by the way, science classes. And they would give Kindles free to the college to give to each student who was in that class. So these were pilot programs. And they did it at 6 schools. So the first 5 schools, 4 schools. The National Federation for the Blind filed a complaint with OCR over this plan. And in the 5th one, Arizona State University, the United States went into court to sue them. What was the problem? What was the problem? After all, the Kindle reader can read aloud, right? So you think, well, gee, maybe this is an accessible approach. Maybe this solves a lot of problems. So here's the problem. To turn the voice on the Kindle reader on, you have to use a pull-down menu. Guess what? Pull-down menu is not accessible to people who are blind. Had they spent 50 cents per Kindle to put a button on it, so you hit the button and the voice reader starts reading, it would have been accessible, right? But they didn't, and it wasn't accessible. So ultimately, all these cases were settled, and in the settlement agreement, the schools had to agree that they would no longer purchase. So we're talking about this whole issue, when you buy things, make sure it's accessible. They would no longer purchase, require, or even recommend Kindles until the device was fully accessible to people who are blind. So they had to, for the first time, define what fully accessible means. And this is the time at which these 4 standards that I told you now are becoming ubiquitous were articulated. So that's why I say if you have a chief information officer, you might want to read to them from the Kindle guidance, or what's called technically the Emerging Technology Guidance that was issued jointly by OCR and DOJ. And by the way, OCR and DOJ rarely agree on anything. So it is, it really means something when they can together agree we need to adopt this standard, and they put out this guidance. And it's in your notes, by the way, the tag to get there. Okay. So I'm going to see how many of these cases I can do from memory in the time that's left. So South Carolina State was really the first big case that OCR did on this issue. It was initiated as a compliance review. And the reason reading this letter might be helpful to you or your chief information officer is it lays out for the first time what makes a website inaccessible, right? This is what is not going to be acceptable to us under the law. So most websites are chock-a-block with PDFs. If the PDFs do not have tags, it cannot be read by adaptive technology. Same thing for graphics. If you have a chart, columns and headers, I think that's the 2 axes, right? Columns and headers. So let's say it's for course registration. And you're using adaptive technology to read that chart. Unless there's a tag on each line, you cannot tell where you are on the chart or which direction you're moving in. So if you have this chart, the chart itself also has to be tagged for each of those lines. Otherwise, the person won't know the specific reading order. Videos are captioned. That's great. That's what we need for deaf people. But if you can't figure out how to get the video to start playing, it does you no good. And in most instances, that's a picture, not an actual item. So you could run your mouse over it and it won't do, and you won't hear anything. You could run right over that little triangle, the forward pointing triangle. And if you're blind, you can't hear the video. Not that it's not captioned, but you can't start it. It's kind of like the Kindle not having the button, right? So you need to do that. Fields have to have tags, again, so screen readers can find them. Next came the Louisiana Tech case. And the interesting thing here is they decided that the only person who had any sense in this campus was the DSS officer. So they gave the DSS officer a lot of responsibility for solving the problem. And remember I told you don't let a student spin in the wind? So here was a blind student who was taking a math course, and they were using My OM Lab. So I just want to warn you, if you ever see the word my, it's probably not accessible. All right? Just stay away from the my's. That's my advice. In any event, the way My OM Lab worked was you would do a problem, and if you weren't correct, it would take you to another problem to help you learn how to do the problem you didn't get correct. Then you'd take a quiz, and if you got the quiz answer wrong, you could take a makeup question and raise your score back up. So here was a blind student who can't use the My OM Lab program, and the school says, well, we'll have a tutor sit with you and read to you from the screen. But the way this works then is the person has no chance to raise their grade, correct the problem, get to the underlying problems. So it doesn't work. So the student goes to the professor and says, this isn't working. And the professor says, here's the 800 number for the My OM Lab manufacturer. You call them and tell them what your problem is and let them fix it. Are we letting somebody spin in the wind? So it gets worse. He goes back to the professor and says, that didn't work. And the professor says, okay, I'll have my teaching assistant call My OM Lab and have my teaching assistant fix it. And the teaching assistant, by the way, did nothing. So what happens is the person decided to file a complaint with the United States Department of Justice. Leave a student spin in the wind. That's likely what's going to happen. So they negotiated a remedial agreement. And the remedial agreement is all technology and content purchase will be accessible. So no more ad hocism. All new websites will meet the WCAG 2 level AA standard. And then over time, they will work back over the old websites to make them accessible in the same way. The next big case was against the University of Montana. And I'm not going to go into this in much detail, but again, I want to urge you to share this letter with your CIO. And the reason I want to urge you to share it with your CIO is it is full of definitions of terms which are subsequently used in other agreements with DOJ. So your technologist wants to know what is electronic and information technology as a matter of law. Look at all the things that it covers. Right? How many of you are using clickers? Yeah, not accessible, right? At least last time I checked. Telephones, ATMs, learning management systems, search engines and databases. All these things are covered under this heading of information technology. And then they set out the definition of accessible, and you'll note it's independently acquire the same information, engage in the same interactions, have the same services over the same time frame with equivalent ease of use. Where did this come from? This came from the Kindle letters, right? But now we're seeing it in settlement agreements. And then they put in acquisition standards. So if you got the person who's doing the purchasing, this is the letter for them to look at. And then they set up an elaborate quality control system. So they said, look, if we're now going to require you to be accessible, and you've promised us you're going to be accessible, how are you going to do it? So they're going to do it in a number of ways. One is they're going to hire an outside consultant to independently test the accessibility of the websites. They're also going to survey students with disabilities for them to report on any problems that they may be having. So through 5 different approaches, they're going to see to it that the quality control standards are being met. And this is the most recent letter, and it's to the University of Cincinnati. And the reason I would like to suggest that you read this letter is because it explains what problems people with disabilities have when they try to use inaccessible websites. And it makes a lot of sense over how are we going to come into compliance. What steps have to be taken on our campus to come into compliance. And I think, and Youngstown was issued at the exact same time as Cincinnati and follows the same approach. If I was going to read one letter, by the way, I would make it the Cincinnati letter. If you're going to pull one letter from OCR to read in this subject area, you're going to learn more from the University of Cincinnati letter than any other letter. And I think with that, I'm going to stop and take your vexatious questions. Thank you. Thank you. I'm running out of energy too, and I can tell it, so better to be responding to your concerns. Yes?
Let's say you have a student who has been enrolled in your program for a while, hasn't done well, suspects there's maybe an underlying diagnosis, has neuropsychological evaluation, turns out there's an LD or ADHD, and he wants to retroactively go back and have grades removed from his transcript. What do you think is the court case that's covered?
So OCR's perspective is you do not have to go back and retroactively remove the grades. I think that you may decide that if the grades do not reflect the student's performance and potential, it would not be a fundamental alteration to do so. So I'm making a distinction here. I'm not saying you have to do this. What I am saying is it would not be a fundamental alteration to do so. Right? So. The point is the student didn't know they had the disability, and what you're then measuring on the exams, what the grades are then measuring is the disability, not their aptitude or knowledge. Right? Does everybody want me to do like 2 seconds on service animals? Is that okay? All right, just because I only saw one question, is the tail wagging the dog? That's really not about service animals. Okay, here is the important insight I want to share with you about service animals versus comfort animals, assistance animals, and pets. A service animal actually does something. It is not passive. In other words, the individual with a disability has a need, what we call a trigger. And the service animal hears the trigger, senses the trigger, sees the trigger, whatever, and it then performs a task. I'm going to open the door for the deaf person so they know someone's knocking on the door, right? I'm going to put my paws up on the person who's about to have a seizure to let them know you need to sit down. I'm going to get between the kid with autism and the wall so that he doesn't knock his head on the wall. These are all active things. I'm going to guide, I'm going to pull, I'm going to retrieve. These are all active things. Those are not comfort and companion animals. And service animals can only be a dog. There are no service ferrets, no service snakes, no service parakeets. And by the way, no service capuchin monkeys. That was a big debated issue. No service capuchin monkeys. For the service animal, you cannot require the animal to register with Disabled Student Services. You cannot require the student to provide documentation to Disabled Student Services. You can ask the student You know, is this a service animal? Has it been trained to perform a function for you? And you can ask them to state what the function is, not what the disability is, what the function the animal performs is. And why? So you know it's not passive, right? There's a slight exception to this for miniature horses. And I used to tell a lot of miniature horse jokes, but it's getting late in the afternoon, so I'll spare you. Why miniature horses? A couple of reasons. One is a service animal might last 6 or 7 years. Excuse me, a dog in service might last 6 or 7 years. A miniature horse could last as many as 20 years, right? So all that familiarization and training and so on and so forth that you have to go through. But the primary reason is in some cultures, particularly Muslim cultures, dogs are considered filthy, right? You remember the pictures of Abu Ghraib where the guards are holding the dogs and people. That is to insult them and demean them. That was like, those just weren't dogs to be dogs. They were used to humiliate people, right? So for this reason. But if you want to bring your miniature horse on campus, for that, you do have to go through Disabled Student Services. And the reason is because the miniature horse may not be permissible every place on campus, whereas the dog, with the possible exception of a bone marrow transplant ward, is because of infection, right, is going to be permissible any place on campus. Now, the dog cannot be disruptive because then it's not a trained service animal, right? Dog must be housebroken. If it's not a trained service animal. So if you have somebody comes into a computer lab at night and their dog is not sitting really nicely like this dog is, but running around and nipping at everybody's legs, it's not a trained service animal, right? Okay. And by the way, the miniature horse, there are very few miniature horses that are housebroken. Okay, but there are some that are trained. Okay. Now, let's say what, yes?
Just an opposite question. If someone, if a student said, you know, I need to have a cat.
That's not a service animal. Yeah, that's not a service animal. Not a service animal. Now, I'm not through. Okay. So now we're going to talk about comfort and assistance animals. Okay. So comfort and assistance animal can be almost any animal except a reptile, because they are apparently extremely disease prone, and cannot be, there's one other thing, and it can't be a capuchin monkey. Okay. The reason, by the way, capuchin monkeys were taken off the list is the CDC said they're too similar to human beings so that they spread disease. So capuchin monkeys can like spread flu through a dorm. Right? Okay. So, but it could be a cat, could be a ferret, could be a gopher. But that request, A, has to go through your office, has to be a documented need. And at this point in time, the only place that animal is going to be permitted is your dorms and your commons connected to the dorms. At this point in time, you have no duty to allow that student to take the cat, for example, to class or to the lab. The reason I keep saying at this point in time is because OCR can't make up its damn mind about this issue, right? And it's giving contradictory advice. So I tell my clients, when OCR really gets it together and is really clear in this issue, do what they say. But at this point, what the heck, take advantage of their disorganization and just say only in the dorms or the commons area. Now, it also has to be documented. So it has to be documented as necessary. Okay? And it also has to be housebroken or litter box trained or whatever it is. And it still has to be under control. So when the person takes their cat out of their room, the cat has to be under control. Now, one of the things that the Justice Department can't seem to get very clear on is, okay, I'm going to permit this dog in the dorm. I'm going to permit it on campus every day. Can I at least require the dog to have a tag issued by my office? No, you cannot. Can I require the dog to have a rabies tag? So this is what Justice says. If you see a dog on campus that is being ill-treated, not groomed, looks sickly, doesn't have their rabies distemper tags, call animal control. It's not a violation of the ADA to turn a service animal into animal control if you have a reasonable basis to believe it's not in compliance with the law. But don't you be the animal control officer. Okay. Now let's talk about documentation for the assistance animal. By the way, remember I said the service animal is an active animal, right? It can do something active. The assistance animal is called an assistance animal because its role is passive. I feel better when my boa constrictor, oh, that's a reptile, can't have it. I feel better when my cat sleeps with me in my bed at night. I have a sleep disorder, but when I hear my cat purring at night, I can fall asleep. Okay. The question that you're going to have to figure out is like, how strict are you going to be? And the University of Nebraska at Kearney was sued by the Justice Department because it asked a student with a psychiatric disorder for more and more and more documentation. So it was clear they were just asking for documentation so they didn't have to let the damn cat in the dorm. So you can't do that. But neither, in my opinion, do you have to accept a note on a prescription pad. Jimmy has ADHD. He loves his cat. Let him have his cat. It's like, what's the nexus between the functional limitations and the accommodation? Now, I'll tell you where I might let a service animal not only in the dorm, I might even let him in the classroom. So I asked the faculty at the Palo Alto Polytrauma Center, what do you do for people who have really, really horrible PTSD? Answer, I send them to Fort Bliss, Texas. I give them medication. I give them individual therapy. I give them group therapy. I get them in a really, really rigorous physical exercise program. So big question is your physical perfection center, whatever where people go to look buff on Saturday night, is that accessible to people in wheelchairs? Is that accessible to wounded warriors? Because unlike the people who want to look buff on a Saturday night, they need that upper body strength, right? It's also very, very important treatment for PTSD. And we give them as much competitive sports as possible. So you have an intramural program. Does it have anything for people in wheelchairs? Right? A good question. But I'm getting aside. So they said they send them to Fort Bliss, Texas. They give them this experience. And before they leave, they give them a big German Shepherd. So now you've got somebody who comes, and the German Shepherd's role is entirely passive. It doesn't retrieve anything. It doesn't pull anything. It's just passive. It's a comfort animal, right? I probably would leave it alone anyway, but if I was going to ask for documentation, here's the ideal documentation. I'm treating my client, Sarah Jones, for war-related PTSD. Without her dog, she needs 100 milligrams of Milleril a day, and she might as well be a vegetable. With her dog, she needs 40 milligrams of Milleril a day, and she can be a fully functioning student. I don't care whether that's a service animal or a companion animal. To me, that's like convincing documentation. So what I am suggesting is maybe you want to make a few exceptions for not just the dorm, but for everywhere where you really have this kind of compelling, clear documentation. But the kid with ADHD is like, he's got ADHD and this is his pet cat. It's like, no, that's a pet. And unless your campus has a no pet rule, keep the pets out. Right? Is that helpful on this issue? Yes? It's a matter of state law. So it's not a service animal because it's not trained. It's a comfort animal. So first of all, service animals in training are a matter of state law, and it varies from state to state. So I can't tell you what to do about that. Somebody has a puppy. I guess the puppy is a comfort animal. The question is, did they give you adequate documentation that they needed the comfort animal, and is it housebroken, right? And is its conduct not disruptive, right? Right.
So, Paul, this is
Thank you, everybody.
We appreciate you so much.
Made it.
Yeah, no, I thank you all for coming, and I thank you all for staying. I wish I had an award for everyone who came today, and especially you. And so I hope we can reconvene at some time and further explore some of these very, very important issues. And the other thing is that some of your slides originally
Yes.
were not in the packet, but I have, if you, Paul has generously offered to allow us to copy those and send them to you if you want them. So if you do, please leave your card or your email with us, and we will get them to you eventually.
And don't put them up on the internet, because I'm serious, I will hunt you down and shoot you.
Yes, and also we have some more goodies over here, and hopefully you will enjoy them and take some of them with you on your
Thank you
ride
all.
home.
Thank you very much.
Thank you all for coming.
Thank you.